Good afternoon. Welcome to Outer Temple Chambers, and thank you for those of us who are here in person for joining us, and for all of those who I can't see who are online, who hopefully can hear and see us. This event has been going on for a number of years now, and we're glad to see that it still remains popular and relevant. We have divided today into two parts. The first part you might call the more traditional travel law aspect. We are looking at the very relevant issue to start off with of Spanish penalty interest, and we will be hearing from Anna Romero and Dan Clarke, who I will give a little bit more of an introduction to in a moment. We are then reflecting very much the changing markets that have come with Brexit, focusing on co-counselling in clinical negligence claims. And we're very lucky to have Victoria Williams from Stewart's Law and Natalia, who I have not asked how to pronounce her surname, so will remain as Natalia for the rest of the day. Continuing with the theme of cross-border clinical negligence matters, then you'll get to hear a little bit more from me, and I will be joined by speakers from Poland, Sweden, and Turkey, whose names I have practiced a lot, but do not have my notes in front of me, so we'll be saying them later. There's a big build up to that. Looking at how clinical negligence cases vary in those particular jurisdictions, and I hope that will be interesting. That's the end of the first half. We then move to the coffee break, after which you will be in the capable hands of Gerard McDermott, King's Counsel, who will be focusing on the issue of aviation claims. And there will be, what I'm told, will be a fascinating yet informal discussion on aviation issues with Sarah Crowther, Silk from Chambers, Peter Neenan from Stewart's Law, and again, I've not asked how to pronounce John's name. John, are you here? John, how do I pronounce your surname? I'm terribly sorry.
Commentis, for the T is silent.
Brilliant. Thank you.
Very grateful for that. I've been drinking the tea all day.
And after that, hopefully you'll have had your fill of travel and aviation information, and we can all go out for a drink after that. I have been told that there are no fire tests due today, so if the alarm does go, there might be a fire, hopefully not. If you could all leave the building in an orderly fashion and head not that way, but that way towards Brick Court, and I'm told there's a fire marshal who will be able to give us further directions. Hopefully that will not transpire. Usually it is the junior who has to do the preparatory work for the Silk. When Gerard told me this morning that in fact I was chairing the morning session instead of him, he very helpfully provided me with some information about all the speakers, so it's very kind of him. So the first speakers today, speaking on Spanish penalty interest, are Dan Clarke, barrister at Outer Temple Chambers. As you all know, Dan is a leading travel law and personal injury junior and has a particular specialism with cases of an international element, including claims raising conflicts of law and jurisdictional issues. He was the lead junior in the Supreme Court case of Brownlee, and he also undertakes quite a lot of clinical negligence work. And what I also didn't know is he's also an accredited mediator. So there we are. So that's Dan. Dan will be looking at Spanish penalty interest from an English perspective. And we are very honoured to have Anna Romero, who I'm sure all of you will know. Anna is currently the president of the Pan-European Organisation for Personal Injury Lawyers and is taking that association from strength to strength. And we recently enjoyed an absolutely superb conference in Dublin, as well as many other great events this year. Anna has recently found her own firm, Astron Legal, together with Natalia. And that is also going from strength to strength. A renowned lawyer both in Spain and as an expert on Spanish law. And you'll hear more from me later, and I'll just step to one side and hand over to Dan and Anna.
Thank you very much, Ian. It's a pleasure to be here at this conference organized by Outer Temple Chambers. I think these forums are crucial for personal injury lawyers practicing in travel law. And I'm honored to have been asked to participate, and I look forward to listening to the other speakers and learning. And we always come out of these conferences being better lawyers, and I'm sure today it will be no exception to that. And the topic I've been asked to talk about this morning is not very exciting as such, but at the same time it's something that is often subject to litigation in Spain. And I can see also that in the UK is a topic that the English courts are looking into, and I will tell us about it after. It's a topic with many gray areas. You will see from my presentation that is full of yes, but, however, so there is no straight answer for most of the questions or the issues that we will discuss today. But if I may start this presentation by my conclusion, is that when you are dealing with Spanish penalty interest, prepare your case from the very beginning. So that's if I want you to come out of this talk with something, is that you have to prepare from the outset. And that's what we do with our cases in Spain. We always ensure that our strategy towards penalty interest is focused from the very beginning. And I will advise you to do that in your cases in England as well. And I will now go back. I will not finish my presentation just with a conclusion, but I will give you some feedback, some food for thought, some key issues for you to bear in mind in that exercise. So why is penalty interest so important for us in Spain under Spanish law? Why is it such a crucial element of our claims? Well, the reason for that is that we don't have anything else. We don't have Part 36 offers. We don't have a cost regime where we can recover costs from the defendant if we are successful. We have absolutely nothing else but penalty interest to incentivize out-of-court settlements, to push insurers to comply with their duties under the cover in the policy. So for us, it's the jewel of the crown, you would say. Something that really makes a difference, both in the process of the claim and also to the outcome of the claim, as we will see afterwards. But still something that is subject to continuous challenges, not only in courts. We've recently heard of a political party in Spain who is asking for a penalty interest to be erased on the basis that it doesn't exist in other judicial systems in Europe, but forgetting that other judicial systems have other tools to push these out-of-court settlements, payments, interim payments, and we don't have anything else. So this 20%, the magic 20%, happens, and it happens often in some areas more than others. We will see that it applies to every claim where there is an insurer involved, where you pursue your claim against the insurer, but not all the courts take the same approach. Some key facts to bear in mind in relation to penalty interest and the regulation of penalty interest under Spanish law. It applies to all claims where your defendant is an insurer, because we have this direct right of action under Spanish law, which allows us to involve the insurer in the claim and pursue the claim directly against them, with or without the insurer. It's not necessary to have the insurer involved, but if you want to claim penalty interest, you always have to include the insurer. The insurer in any field of activity, it could be the obvious compulsory motor insurance, but any party who is insured will be able to pursue a direct of action against such insurer. It could be the insurer of a hotel, of a hospital. Sorry, louder. Yeah. So anytime you've got an insurer, you will be able to pursue the direct right of action against them, and therefore claim for penalty interest. And as we were saying before, the purpose is to incentivize out-of-court settlements, to incentivize payments out of court, to incentivize negotiations. and penalize and justify delays on the side of the insurers for reasons that do not have any justification, any cause that can be justified under the law. It can only be obtained if awarded by the court. So we would not get a penalty interest if we are in out-of-court negotiations. That's why it actually helps us to go ahead with those out-of-court negotiations, because the insurer will not be penalized with the penalty interest. But for us, in some occasions, it would be better to settle out of court. And it will apply to both general and special damages. So it will apply to the whole damages that you obtain in court. And the judge will have full discretion to award this. Full discretion in the sense of the judge will be able to analyze the reasons why we are claiming a penalty interest and the reasons why the defendant thinks it shouldn't be awarded. And we'll look at the whole picture. So that's why we were saying before that you need to prepare for that. You need to have strong arguments on your position, on your side, to get the judge on your side. But it will not have, the judge will not have discretion on the calculation of interest. This is set by law, and this is set also by conclusive case law from the Supreme Court. And we will see later on how it is calculated. So, as I was saying, a penalty interest will be raised, will be awarded in all jurisdictions, be it civil jurisdictions, civil courts, employment courts, criminal courts when dealing with damages, and also with administrative courts when dealing with claims against any public body. But their approach is completely different. We see that civil courts are much more in favor of awarding penalty interest to claimants. They have a very restrictive approach in terms of the justification for not awarding a penalty interest. So you will be in a much stronger position to get penalty interest in the civil courts. And this will be also for insurers, but also for the Spanish MIB. However, administrative courts, they take a very, very different approach. Even though you can file a claim not only against the public body, but against their insurers and exercise your direct right of action against the insurers of a public body, it is very, very rare that an administrative court will award penalty interest. And they will be very open to finding justifications for not awarding penalty interest against the insurers of a public body. And in this area, I would like to mention one judgment that my colleague Natalia, she obtained a couple of years ago, a very successful judgment. It was a wrongful birth claim pursued against the Balearic health system. And the Superior Court of Justice awarded penalty interest for the first time in Spain against the insurers of a public hospital from the date the claim had been filed against the out-of-court claim had been filed against the public hospital. So that was, excellent news. We thought, well, new era, new opportunities. Well, the same court in subsequent subsequent judgments changed the position because we don't have a system of precedents in Spain. So the court can say one thing one day and the following day change their view and say the opposite. So it's still very, very uncertain. But hopefully, with this preparation, with these arguments on our side, we will be strong, building a stronger case law that supports this kind of awards of penalty interest in administrative claims. So how do we calculate penalty interest? We have to, first of all, think about when it's going to start and until when it's going to accrue. On the one hand, the starting point, the case law is very conclusive in that it would be the date of the accident. In the judgment of the Supreme Court of the 5th April 2016, which has been also confirmed by subsequent judgments, the court confirmed that the right of the victim is the birth of the right of the victim to obtain redress is from the moment the accident occurred, not from the moment of the judgment. The judgment is a declarative statement of what the victim is entitled to, but it doesn't mean that the right is won at that point. and it will accrue until the moment that payment is effected by the insurers. The final payment, if there are interim payments, they will be taken into account in the calculation, but the interest will continue to accrue until the final settlement has occurred. And how is this calculated? So we have, on the one hand, the 2 first years after the accident, where the legal interest increased by 50% will apply. And subsequently, from the second anniversary of the accident, the magic 20% will come into place. And that will really make a difference to our case. Think that, for example, if you've got a claim, I mean, litigation, I guess everywhere, but in Spain, it can be a very lengthy process until you get your judgment. It can be several years, and between that and the time that you take to prepare your case and everything, if you've got a case where it takes you, I don't know, 4 or 5 years to reach a conclusion, the increase in your damages is great. It can be huge. I just put an example here. For example, if we have an accident which occurred in April 2019 with a final award on damages of 150,000 euros in October 2023, the interest could be more than 88,000 euros. So an increase of more than 50% of the figure on damages. So as you can see, this is a crucial element of our claim. And I know that for the litigation in England and Wales, and Dan will tell us more about it, one of the elements that has been looked at is whether this penalty interest is a procedural or substantive law. This is something that we haven't looked at in Spain. The courts in Spain haven't considered these aspects. So it's something that we have to build our arguments and our strategy and our position to defend one or the other based on doctrine and based on the opinion that each of us has. But there's no case law that will tell us or will guide us on this. However, one important thing that I think that is relevant to bear in mind is that penalty interest is not the only type of interest that we have in Spain. We also have procedural interest as such. So that leads you to think, I mean, if we have procedural, then penalty interest shouldn't be a procedural interest, should be something else. And definitely there are differences between the two types of interest. The aim of penalty interest is different than the one of procedural interest. Penalty interest is aimed at repairing the harm caused by the delay in payment on the side of the insurer, where procedural interest penalizes the delay after the judgment for not complying with the award given in the judgment. Penalty interest is regulated in substantive norms such as the Insurance Contract Act and the Civil Code, whereas procedural interest is regulated in the Spanish civil procedure rules. And also the penalty interest must be requested by the claimant, whereas the procedural interest is applied ex officio by the court. So we definitely have a scope to argue there that there's something else. I mean, it's not clear, but definitely there's some arguments there to say that in principle it would seem that penalty interest could be substantive law. And there's this judgment, the judgment from the Supreme Court of 1st February 2021, which even though doesn't mention at all anything regarding procedural or substantive law, it kind of also gives us further argument in support of this. This relates to an accident in Morocco involving a Spanish vehicle where victims were domiciled both in Morocco and in Spain. The claim was pursued in Spain, and under the Hague Convention, the applicable law for the Spanish victim was Spanish law, and for the other two victims, the ones domiciled in Morocco, Moroccan law was to be applied as concluded by the court. The court in this case concluded that for the victims domiciled in Morocco, punitive interest or interest at all had to be regulated in accordance with the law of Morocco, not the Spanish law, even though the case was being pursued through the Spanish courts. So that also leads you to think, I mean, there's a difference there. Otherwise, the court would have applied its procedure, which is Spanish law and Spanish penalty interest. Important to bear in mind in the preparation of your claim, the obligations of the insurer, and we will see after the obligations of the claimant. So the insurer has obligations, and if they fail to comply with those obligations, it is more likely than not that penalty interest will accrue. The obligations of the insurers are contained in the Insurance Contract Act and also specifically in what concerns road traffic accidents in Royal Decree 8/2004. So obligations of payment, of offers. So within 40 days, there is an obligation of a minimum payment, and then within 3 months from the date of the accident, there will be also an obligation to make payment, or it could be an interim payment, but in accordance to the evidence available to the insurer at that point. And that obligation is developed further for road traffic accidents in the context of accidents occurring involving motor vehicles, because in that case, there will be another obligation of issuing a motivated offer. A motivated offer is a formal offer which with its own requirements and characteristics that the insurer must comply with, because failing to that, again, will turn into a penalty interest accruing. So the motivated offer must contain evaluation of the damages, must attach the medical reports based on which the offer is made. It cannot oblige the claimant to renounce to further actions. So the payments that may be received after this motivated offer will not impede that the claimant pursues a further action for the remaining damages. And if the claimant doesn't respond or doesn't accept this amount, in order to stop punitive interest, the insurer can pay the amounts in court. This is, again, something that it will need to be explored, how you can match these requirements, which in a way they are procedural requirements that are established under Spanish law. How would you be able to implement something like this in the courts of England and Wales? How do you pay something in court? Or whether a payment made in the Spanish courts will be sufficient. So we've got two different systems that we need to match here. It's a very complex situation. But still, these obligations are there, and failing to comply with these obligations are most likely to lead to the judge awarding penalty interest. But the claimant also has obligations, and these obligations, again, are different to the ones a claimant would have in England and Wales, in the UK. So on the one hand, and very important, is that the claimant has an obligation to cooperate, to disclose medical information from the outset, as soon as that medical information or medical evidence is available. I guess that's something different to what a claimant would be expected to do here. But it could be regarded by the court in a negative way, and in a sense that the claimant is not cooperating and is not allowing the insurer to fulfill its obligation. Also, the claimant has an obligation to mitigate the damage suffered. So that means that the claimant must undergo the necessary medical treatment, medical follow-up, and that, again, has to be the insurer has to be informed of what is happening. So there must be a collaboration, there must be an exchange, a continuous exchange of information there in order for the claimant to justify that the insurer has not complied if they haven't complied, or to avoid the insurer saying, well, there's a justified cause why I haven't complied with my duties because I was not able to do so. And this justified cause is a very relevant one. It's a very relevant element when claiming for claiming penalty interest. Article 28 of the insurance contract that specifically refers to this. And it specifically refers that there will be no penalty, no accrual of penalty interest where there's a justified cause for the insurer not to have made the relevant offers or relevant payments. It has a restrictive application by the courts, mostly by the civil courts, as we have seen. And this, in the context of this justified cause, the existence of a procedure to, because of this disagreement on liability, on damages, will not be a cause that will justify the non-payment on the side of the insurers, and this is confirmed by our Supreme Court. However, facts that are related to the existence of the cover or the reality of the accident or the lack of knowledge on the side of the insurer with regards to the damage that the claimant has suffered, these will be causes that could be regarded as justifying the lack of action or the lack of diligence on the side of the insurer within what relates to payments. And this duty of the claimant for collaboration and disclosure has been confirmed in a recent judgment of the Supreme Court, where the Supreme Court acknowledged that the insurer didn't have the elements necessary to comply with their duties. So that's why it is so important that we make sure that the duties of both parties are complied with in order to avoid these kind of challenges. So in what concerns a strategic approach, what do we need, or what would I think you would need to consider from in your cases when there's this element of punitive interest, when there's Spanish law applicable to the case, and you want to ensure or have the best chances of getting an award for penalty interest? Well, first of all, we need to know if the defendant is insured. There's an obligation under Spanish law for disclosure of insurance details, and often this would happen voluntarily if you address a communication, a formal letter to the defendant, and they may agree to provide you with the relevant information that allows you to then get the insurer on board. If they don't, there is also the tool of disclosure proceedings, which is something that will not cease jurisdiction in Spain and will allow you to have that information and those details to know where you stand and whether there's an insurance in place and whether you can include that the insurers as in your claim. Another thing is whether, I mean, in Spain, that's what we would do, but I'm not sure whether that's something that you would consider doing in your particulars of claim, and is making a specific reference to the fact that you intend to claim punitive interest under Article 20 of the Spanish Insurance Contract Act. We would do that because the Spanish Supreme Court has been very reluctant to apply punitive interest when it hasn't been claimed by the claimant, when it hasn't been included as part of the claim. In our initial claim, we must tell the court what we are claiming for in damages, but also in terms of interest. And this judgment clearly said it. It was a judgment related to a claim where punitive interest was not mentioned in the original claim and therefore was not awarded. Another important thing, as we said before, ensure that there is that collaboration and disclosure in place so that there is no criticism on the side of the insurer to not being able to make any kind of offer because of not having the tools or the elements to do so. And on the side of the insurer, make sure that the motivated offers and payments have complied with the requirements established under Spanish law. All this is a complex exercise that I would recommend doing from the outset of the claim, and doing, these forms, these international forms are important to make sure that you get the best outcome for your case and that you work together with your foreign lawyers to ensure that this happens. So that's all for you.
Thank you very much.
I hope I was on time with.
Thank you. Thanks. Thank you very much. Hello, everyone. It's very nice to see you all. Hello, everyone who's watching online as well. So I'm going to talk about the reception of those Spanish law principles into English law. Now, applying foreign law on interest is nothing new to the English courts, but the Spanish penalty interest provisions are different because firstly there's their penal nature, and then there's the fact that the rates are so much higher than anything we normally encounter, and so there's often a lot at stake. It can double the damages, it can even sometimes dwarf the damages that are otherwise recoverable, lead to much big differences between the results, and that's something that's a bit alien to English personal injury lawyers. Anyway, because the stakes are high and because the issues are contestable, that's led to a flurry of recent cases on this topic. So how do the Spanish principles translate over? Well, not smoothly, I think is the short answer to that. I mean, in the cases that have come up in this recent flurry, Spanish law applies by definition. As it happens, there weren't any issues about liability in any of them. And interestingly, importantly, not really any significant disputes about what Spanish law is. Spanish law obviously having to be proved and pleaded in every case, in every case separately. There's the potential for another level of complication, and if there were serious disputes about what Spanish law is, but happily it doesn't appear that complications have arisen, at least so far. So in all the cases that have come up, it's been litigated, if not quite as a standalone issue, then certainly the lead issue, and on essentially agreed principles of Spanish law, pretty much along the lines that Anna's just explained. So the big issue, the first big issue is, are the Spanish penal provisions substantive or procedural for the purposes of Rome 2, in other words, the retained Rome 2 that we've got in our law? If they're substantive, in other words, if they fall within Article 15, then the issue is governed by Spanish law. It's a matter of applying the Spanish rules, as Anna's just explained, and there's no discretionary element to it. If it's a procedural issue, then it's governed by English law, as the law of the forum. And then interest is a discretionary matter according to either the Senior Courts Act or the County Courts Act, depending on what court you're in. If it's said to be substantive, then the next big topic that comes up is, well, can the defendant use Article 20.8 to escape having to pay penal interest? If it's procedural, then the next big topic is, well, can and should the court import the Spanish principles via the English court's discretion? So those are the topics. How have they been dealt with? Well, the first significant case was Scales and MIB. As I said, liability admitted. This was a case under the old Romero. The damages outside interest were about €374,000. There's a claim for penalty interest of €180,000. So adding a lot to the claim. In this case, Spanish penalty interest was awarded, and it was done essentially on the basis, well, definitely on the basis that the Spanish principles that Anna's just explained would be applied by the English judge. In other words, as if they were the Spanish judge. And it was said whether as a matter of rule or discretion. Now, importantly, there wasn't actually any argument in Scales about whether the rules were substantive or procedural. It was agreed by both sides that the Spanish principles should apply. So no argument, no ventilation of the arguments on either side of the substance procedure point. So arguably not really an authority on either side of that debate, but that, as you'll see, has not stopped it being cited as an authority on the issue. However, in Troke, which is the next case that came up in November 2020, there was argument on that specific issue. So it's another case where liability was admitted, and it's an appeal from Plymouth County Court. And in Troke, Mr. Justice Griffiths decided that the Spanish penalty interest provisions were procedural, not substantive. And he went on to say that that he was going to uphold what the county court judge had done, which was simply awarding damages according to the English rates, which I think then were 0.5% for special damages and 2% on generals. But he did go on to say that, well, he might equally have applied the Spanish rates, not as a matter of lex causa, in other words, Spanish law, but under the discretion given to him by the lex fori English law. He wasn't bound to do that. So it would have been something that would have been open to the judge below if he'd been asked to do it. So he was saying it's procedural, but you can effectively import the Spanish rules via the He didn't have to decide the 20.8 issue in his case, but interestingly, he seemed quite sympathetic to the defendant's argument, which stands a bit at odds with all the other cases on that. But anyway, that's strictly overturned. Why did he say it was procedural? Well, he gave 3 reasons. The first was because he was following Scales. Well, that seems to be wrong because that's not what Scales was saying, and in any event, wasn't argued. The second reason was that in his particular case, one of the Spanish experts, I think both of them actually, had used the phrase Spanish law contemplates the awarding of penal interest in the following circumstances. And his interpretation of that was, well, it's really a discretion only in Spanish law, it's not a rule. But that doesn't seem particularly convincing because it's not a discretion, certainly not in the sense of the way that interest is awarded in English law. It is a system of rules. The third reason he gave was, well, isn't it really a sort of sanction to enforce compliance with procedural rules rather than a form of compensation? That point, I think, probably does have some, is quite compelling, but the other point's probably not. Right, that's how he reasoned it. So that's where the matter was left there. It was a sort of hiatus then for a bit until October 22, when Sedgwick and Matfray came out. Again, quantum only case with interest being probably the lead issue. Mrs. Justice Lambert followed Troke, so she said she agreed. Spanish penalty interest procedural, not substantive. In her case, that she was willing and able to go on and award Spanish penalty interest via the English court's discretion. So she said, fine, it may be a procedural matter, it may be governed by English law, but using the discretion that statutory discretion that I have of going to award it essentially as if the Spanish law principles applied. And her reasoning for doing that was, it seemed to her that the right approach was to try to put the claimants in essentially the same position as if they had been litigating the case in Spain in front of a Spanish judge. There shouldn't be a difference between what happens, the outcome in England and Spain, which is quite a sort of broad proposition, because once you start to get into that, then you could sort of bulldoze quite a lot of things out of the way. But that was the kind of that was the reasoning that she used. As I say, she followed Troke, the reasoning in Troke as regards the question, was it procedural or substantive? She went a little bit further, and she interestingly drew a distinction between interest, as in interest on damages, conventionally understood, and penalty interest. And said interest on damages is substantive, but penalty interest, like this, is procedural. Which is interesting. It's almost completely contrary to what I was talking about, the analysis has been in Spain. But that's essentially the reasoning that she employed. So she followed Troke, but she sort of added that little bit of extra reasoning as well. Oh, and the other point was, the consequence of her decision was that the defendant insurer was exposed to the sanctions in 3617, CPR 3617 as well. Without really much reasoning, she sort of dismissed that as an issue and said it's not a good reason not to apply the Spanish rate of interest. So there was a kind of double jeopardy issue there. So that was where things were left after Sedgwick. And then finally, most recently, earlier this year, there was Nichols and Woodward, which is a conjoined appeal from 2 county court cases where Spanish penalty interest is the only live issue. And Mr. Justice Martin Spencer in Nichols and Woodward came to the opposite conclusion to the 2 previous cases as regards whether it's substantive or procedural. He said it was substantive, and he expressly declined to follow the reasoning in Troke and Sedgwick. So he applied the Spanish penalty interest rule as a matter of rule, not discretion, reversing the county court decisions below. But then there was a twist because he said, well, if I'm wrong about that, and Spanish penalty is a procedural matter governed by English law, or sorry, of interest is a procedural matter governed by English law, then he would have refused to order it. In other words, order the application of the Spanish rules as an exercise of the discretion. So contradicting Trost and Sedgwick on that issue as well. I mean, as is often the case with these kind of topics, they, like a kind of rolling stone, as they go on, they sort of gather the arguments, build and gather on each side. And what you see in Nichols and Woodward is a kind of, well, certainly the most detailed examination of the topic in the English court so far. It's a sort of a collation, really, of the arguments on both sides. It's a far more detailed judgment than you see in any other cases so far. He gave, Martin Spencer, Mr. Justice Martin, gave a list of reasons why he said it was substantive. Article 15 of Rome 2 was to be construed broadly. It was substantive as a matter of Spanish law. That might be up for debate, but that could be right as well. He said that Dicey tends to be suggested that it should be substantive, and a couple of other commercial and IP cases had as well. I'm talking about interest. Spanish penalty interest is not discretionary, but rules-based, so the opposite view to what the other judges had taken. Therefore, it's a matter of substance. And the drastic effect of the rule suggests that you're talking about a fundamental right rather than a discretion. I mean, some of those reasons are more compelling than others. I'm not sure really that the point about Dicey adds anything, because if you look at that passage, it seems to be talking about interest rather than penalty interest. And whether it has a drastic effect or not doesn't really tell you necessarily whether it's a matter of substance or procedure and so on. So there's a list of reasons there. Certainly they're not watertight, but that's sort of how he reached the conclusion. On the topic of, well, can you apply the Spanish principles via the back door, via the discretion? He was very firm about saying no to that. I mean, he essentially found that the answer to that was no, and no as a matter of principle. He didn't actually say never, but that's sort of the effect of what he said. Because he said it was not legitimate for the court to give effect to the Spanish law provisions. They're intended to operate in a different procedural environment. English law's got its own system of rules and sanctions to encourage early notification and early offers. There are different limitation periods. And it was illegitimate to taint awards of interest on the English statutes pursuant to the CPR with elements of substantive foreign penal law when the claimant's not chosen to subject herself to those rules by suing in Spain. So where does all that leave us? You can see a kind of table there, very crudely summarising where we've got to in the English law at the moment. I mean, the answer is, as it stands, it's a totally open question. Anna said earlier that they don't have a system of precedent in Spanish law. We do have a system of precedent, but you'd be forgiven for not thinking we did, because there isn't really a right answer at the moment to either the question, is it substantive or procedural? And if it's procedural, can you rely on the Spanish penal rules? The High Court authorities are all at the same level. They're all contradictory. I sort of liken it a bit to one of those kind of Scottish dances where everyone gets to try out all the different combinations. That seems to be what the courts are doing at the moment. I mean, if you wanted to try and argue for the position in Nichols and Woodward, i.e. the rules are substantive, but it would be wrong to use the discretion to import those rules, you could say, as Martin Spencer did, well, there was quite a lot of argument before me that there wasn't before the court in Sedgwick or in Troke. So, perhaps my decision carries a bit more weight, or I'm entitled to depart from those previous cases. You might make that argument, but I don't think you could be. I don't think it lends an enormous extra weight to his decision opposed to the others. So what's going to happen next? Well, it's probably picked up from the table, and you may already know. Permission to appeal to the Court of Appeal has been obtained in both Sedgwick and Nichols and Woodward, and there's going to be a conjoined appeal to the Court of Appeal, assuming the case is settled beforehand. And perhaps there might even be a further appeal after that, I don't know. I don't think one can be confident in predicting what the Court of Appeals can say about this. For what it's worth, personally, I think there's quite a lot in the argument to say that what we're looking at here is something that's really a procedural sanction as opposed to a substantive rule about recovery of damages or interest in the usual sense. Having listened to what Anna was saying just now, it kind of reinforced me in that view, because really the Spanish penal interest rules exist in a very particular context where there's no quox, there's no Part 36, damages are set at a certain level very strictly by reference to the Romero, and it's all part of a system. And what's more, this particular bit of the system is really about disciplining and encouraging insurers to engage with claims early, much like Part 36 in our system, although perhaps in a more kind of stringent or heavy-handed way. So I think there's quite a lot in that argument to say what we're looking at here is really a procedural sanction rather than a rule of substance. But we'll just have to see what the Court of Appeal says about that. What to expect from the Court of Appeal? One interesting thing is that so far the way that the cases have all been reasoned is to say the penalty interest is substantive because, or is procedural because, and then list features of it. What there hasn't really been is any of the courts saying, well, this is what substantive really means in the context of Roma 2. These are the features of something that's substantive. Does penalty interest have these features? And there's reasoning around trying to work out or define what the boundary is between substance and procedure first. We'll have to see if the Court of Appeal wants to grapple with that very fundamental question or not. If it does, it'll obviously be a decision that's really important, not just for Spanish penalty interest, but across the board. One thing that another issue that was sort of floated by Martin Spencer, Mr. Justice Martin Spencer in Nichols, was the EU angle to this. He sort of bemoaned the fact that there wasn't before him any evidence about or guidance about how this issue is tackled in the EU. The point being that definition of substance and procedure in Rome 2 is an autonomous EU concept. It's not, strictly speaking, a question of English law. And even after Brexit, definition of substance procedure in the retained Rome 2 that we have in our law has got to be autonomous. It's got to be conditioned at least by the pre-existing EU case law, and perhaps even by the case law that's come out after we've left. So were there to be a reference to the CJU from another EU state on this topic, then that would be highly relevant to our law, I think. But it's just speculative. I don't think there's one in the pipeline. We don't know if there will be. What might come about in the Court of Appeal hearing is there might be some reference to the way the issue is looked at in other EU states, because that would potentially also be relevant to interpreting Rome 2. Not something that's been done so far, but it might be. What other implications? Well, there are obviously lots of other jurisdictions apart from Spain that have interest. Some of them have penalty interest, and so it would be of relevance for that. And also, there's the other side of the coin. So there's jurisdictions like Spain that have penalty interest, but then there are lots of jurisdictions that go the other way and say you simply cannot, as a matter of rule, recover prejudgment interest at all. Is that a question of substance or procedure? That's another issue. And the Court of Appeal decision might have a bearing on that issue as well. That wasn't something I don't think that people really worried about that much in England until recently, because obviously interest in this country so paltry, or didn't hit you too hard in the pocket if you couldn't recover prejudgment interest. But now that you can recover it at significant rates, suddenly that might become something worth litigating. So there you go. That sort of gallop through the English law treatment of Spanish penalty interest. We'll be watching this space, I think.